welcome to this episode of Parley, the Hindu's weekly podcast, where we delve into pressing questions of public importance with insights from experts. I am Aaratrika Bhaumik, your host for today, and the question for this week is the ad hoc appointment of judges a viable solution for reducing pendency of cases? On January 30th, the Supreme Court allowed high courts to appoint retired judges on an ad hoc basis to tackle the mounting backlog of cases. These judges were, however, permitted to hear only criminal appeals as part of a bench led by a sitting judge. A bench headed by Chief Justice of India Sanjeev Khanna also eased a rule set in a 2021 verdict of the Supreme Court titled Lok Prahari versus Union of India, which had limited such appointments to high courts where judicial vacancies exceeded 20% of the sanctioned strength. These judges, appointed under Article 224A of the Constitution, exercise the same powers as sitting judges and are compensated similarly, excluding the grant of pension. To delve into this contentious issue, we have with us today Justice Rajeev Shakdher, former judge of the Delhi High Court and former Chief Justice of the Himachal Pradesh High Court. Also joining us today is Mr. Shadan Farasat, a senior advocate practicing in Delhi. A very warm welcome to the two of you. Thank you so much for joining us today. If we begin with the key question for the evening, which is, can appointing ad hoc judges effectively reduce case pendency? Do you believe that this is a measure which can address the huge backlog of cases that we're seeing, or is it merely a temporary fix that really ignores deeper systemic flaws? Justice Shakdar, if we could begin with you, please.
Yeah, according to me, the move is commendable. In fact, it should have come much earlier, which it did when the Lok Prahari judgment was delivered. But when I said it should have come a little earlier, perhaps it could have been done even prior to 20th April 2021 when Lok Prahari, let's call it the first judgment, was rendered. As noted by the Supreme Court in its recent judgment of 30th January 2025, the arrears have really, to use a figure of speech, have gone through the roof. There is docket explosion. There are some 62 lakh cases which are pending in the High Court, and nearly 4 crores 57 lakh cases in the district courts. The vast majority, nearly one third, are criminal appeals pending in the High Court. So, having regard to these statistics, it is something which is something that we must try and see how it goes. We have done this before, ad hoc judges appointment. We've done this before, but there are instances far and few. You know, in 72, I'm told one judge was appointed in Madhya Pradesh. Then in Madras, Justice Venugopal was appointed to try violence related cases. This was in 82, 84. And then Justice O.P. Srivastava was appointed in the Allahabad High Court to hear the Ayodhya title suit. So these kind of measures have not really taken off in the past. Hopefully now the Supreme Court again being seized of the matter, we may see some concrete steps being taken in this direction.
So you believe that this is an effective measure, sir. Mr. Farasat, do you agree with Justice Shakdar on this?
Yes, in fact, I do completely agree with Justice Shakdar on this. I think it is a provision in the Constitution, both for the Supreme Court and for the High Court, for a reason. And for the High Court as well as for the Supreme Court, there are two kinds of ad hoc judges which is envisaged. And that is, one is that for the purpose of High Court, that you can appoint for a maximum period of 2 years people who are otherwise qualified to be a High Court judge, but that will also their retirement age is same, which is 62, which is the retirement age of your regular High Court judges. And the other is that you can bring in retired judges who have retired from the high court and bring them in as ad hoc judges, and appoint them. And both these provisions, as Justice Shakdar rightly pointed out, have been used very, very seldomly. I think in the context of the Supreme Court, there was one such appointment when Keshav Nanda Bharti was being heard, because most of the judges of the court, 13 at that time, were basically hearing the basic structure case, and therefore, for regular work of the court, they had to get some ad hoc judges also. But my concern really is that the constitution, the way it's quite clear that it really requires the government to play ball. That is, the government has to, the appointment comes from the president, so the government has to agree to any proposal which comes from the court side, and therefore they have to be also on the same boat as the court, that there is a docket explosion, and one of the ways to solve it is through this. I would just say one thing. I think it is possibly an easier solution to find, because these are mostly cases which are old criminal appeals, like Justice Shakdar pointed out, or could be old civil matters. Those are the matters which are being pushed on the board. I mean, it's common knowledge in most high courts today, it's not possible for the court, even if you're working from 10:30 till 5:30, to even hear the regular matters. So regular matters, which in high court is called matters which have been admitted, and in the Supreme Court are leave granted matters, they have really been pushed down the bottom of the board. And these are matters which are regular civil appeals of individuals, like disputes over land, small piece of property, or criminal appeals, or basically the common man's matters, as it were, the final decision is really being pushed down. So it, if for those kind of matters, they are not matters which are necessarily politically sensitive, or otherwise involve anything. So I think even the government should be able to clearly agree quickly. I hope so, at least. And have ad hoc judges, which will at least reduce the pendency to a large extent, because those kind of matters today, most high courts, despite judges trying their best, are not in a position to hear. So I fully endorse it. I'm just skeptical what the response from the government will be, and but hopefully, if it's a positive response, it will be a hugely helpful effort.
Great. Right. Thank you, sir. So you believe that this is a welcome measure. Just to add on to that, the fact that these ad hoc judges will also not have any administrative obligations, they will not be crippled by such administrative duties. Do you think this is also a potential benefit, Mr. Farasat?
Yes, I think it's a benefit. At least the senior judges of the High Court have a lot of administrative work to do. So to that extent, senior judges have really multiple hats to wear. My understanding would be that if you are a relatively younger judge, those roles are not that much. There may be a part of a committee, etc., but at least that won't be taking much of your time. I think the other challenge, which is, it's not sufficient to increase the number of judges, but obviously you'll have to give the added infrastructure for the ad hoc judges. You'll need stenos, you'll need court masters, you'll need those kind of. I mean, a judge cannot function without the necessary, staff. So those will also have to be appointed along with the judge. So without that, just appointing a judge, no judge, no human is possible to just function alone as a entity which is going to dispense justice.
Right, sir. Since you also mentioned that you're also skeptical about how the center is going to respond to such a measure, we have seen delayed appointments when it comes to regular appointments. So, do you think that in the future we could also see a delay in clearing of names of ad hoc judges, or the center selectively approving recommendations? Could these problems also prop up when it comes to ad hoc judges, Mr. Farasat?
See, my sense is, I mean, firstly, in principle, the government has to come on board, because, like Justice Shakdar pointed out, in our country's 75-year constitutional history, there really has never been a movement to solve our docket problem by using this as a policy mechanism to bring on more judges into the system to dispense matters. So the first point is that in principle, the government has to agree. I don't think that has even happened as yet. That's point one. Point two then is, how do you go about determining who will you appoint as ad hoc judges? Now that of course, even for regular judges, I think the way the government has been functioning is rather unfortunate, and we've had some very, very good judges who have not been, either brought to the Supreme Court when they truly well deserved it, or were, really put belatedly to high courts as chief justices, etc. So I think we are all aware of so many of those cases around us. So even there, it's not at all something which is permissible or desirable. But in cases of ad hoc judges, which is to clear, basically areas or general areas of criminal or civil matters, uh, that kind of a pickiness or this thing, you just need a decent legal mind who can understand issues in a civil suit or a criminal matter, and is going to be able to dismiss, not dismiss it, dispose of the matter. And therefore, it's not something which the government should anyways be picky about. Not that in normal matter it should be, but here even there's no reason at all. So I think let's see what happens. But I mean, the government has to first, in principle, agree, and then about the mechanism is a secondary question. I don't think that in principle agreement is even available today.
Right. Thank you, Mr. Farasat. Justice Shakdar, are you equally skeptical about the center's response? And the question is twofold. The second part being that do you believe that this ad hoc appointment of judges can adversely impact the regular appointment process?
To answer your the second part of your question first, I think these two are in different silos altogether. It's like a emergency provision which allows for appointment of ad hoc judges, and therefore it should not impact the appointment of regular judges. Um, as long as the intent is clear and the government is in line with the thinking of the Supreme Court, as expressed in the two judgments, this should not come in the way of regular appointments. Now, see, we can be skeptics, but that doesn't mean that we shouldn't strive to do better, which is what I think the Supreme Court is trying to do. At the end of the day, the consumer of justice is suffering. The courts all over the country are burdened with matters which require urgent hearing. I can tell you from personal experience how much ever you may stretch yourself, there is not enough time and space to satisfactorily deal with every matter. The situation is no different in the highest court as well. Both Shadan and myself, we appear in the Supreme Court and we know the kind of pressure that the judges are facing. So the court has, in a sense, moved the ball a little further in, let's say, the government's court. It's for the government to respond and sort of show their intent. See, at the end of the day, what has the Supreme Court said in the latest order, which was passed on 30th January 2025? They have restricted the domain of ad hoc judges to pending criminal appeals, which I said right at the opening, it's one third of your arrears. So, in the high courts at least. So, that should not be an area over which there can be much debate. The government is aware of the fact that there are a lot of people languishing in jails, waiting for a verdict. This will help them, in fact, even reduce the cost of maintaining jails all over the country. Besides, bring about a sense of, let's say, happiness for litigants all over the country, especially the under trials, who sometimes complete the sentence because the sentence, if they were convicted, while they are still waiting for a trial. So I wouldn't not let's say give my support to initiative like this only because we may have some doubts about what is going to happen hereafter. Let's wait and watch. And this is a petition which consciously the court is not disposed of. It's like a continuing mandamus. Each chief justice will have to push this further. So if there is continuum in the court policy vis-a-vis how to deal with arrears, I think we can achieve a fair bit of success. The challenge, according to me, really lies in picking up candidates because government comes in later. Once you select the candidates, is when the government really comes in. So, firstly, finding the suitable a cohort of suitable candidates with impeccable integrity and technical skills, Of course, you must get candidates to say yes and consent to these appointments, which, according to me, is a huge challenge. And once the court, as an institution, crosses this hurdle, it is then that the government will really say yes or no to a particular appointee. So let's not give up on this only because we think they will not do it. Let's just push this and see where we go.
Right, thank you. So you brought in the conversation about the appointment process. If we could discuss that a little bit more. So the appointment process for ad hoc judges is outlined in the 1998 Memorandum of Procedure. You require consent from various constitutional functionaries at all levels for any appointment to go through. When a bench led by Justice Sanjay Kishan Kaul was hearing this matter on judicial appointments back in 2022, he had also remarked that the procedure for ad hoc appointments is also very cumbersome, which might defeat the purpose. So, Justice Shakdher, do you believe that reforms are required in the appointment process of ad hoc judges? And of course, you mentioned that you were a little skeptical about suitable candidates also. So, what reforms do you think are required?
See, I what I believe is that you have to keep it very simple. If you have too many hoops to cross, then this is not going to see fruition. It should simply be a recommendation by the Chief Justice of a concerned court based on the statistics available as regards pendency. Once he or she identifies suitable candidates after he has obtained their consent, then it should go to the Supreme Court Collegium, who then can straight away recommend to the government. Now, the timelines have already been indicated. The question is about getting them implemented. To avoid delay, it may be a good idea, especially for ad hoc judges, to actually get the government involved in a sense that some kind of a pre approval or clearance, which may hasten the process. As long as the focus is on removing arrears and these are criminal appeals, I think a procedure such as this may expedite appointments. The in a regular appointment, it goes to the state government, it goes to IB, then it comes to the central government, then it goes to the collegium in the Supreme Court after the High Court collegium has selected candidates, and then it goes back to the central government. So the process is long. I don't think if you are looking at candidates who have whose integrity is unimpeachable, that you go through the usual process of getting inputs from intelligence bureau, etc. If you're going to do that, then obviously it's going to delay the process. And these are retired judges. They will not put their hat in the ring if you're going to put them through an IB process. Because suppose the IB, they were to give their consent, and the IB suddenly says no, 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 there is a there's an issue with his integrity, then that's it. You need to come together. Therefore, I think this is one of those areas where the government should come together with the Chief Justice and say, listen, we have no problem with this judge. And that's how it should go. That's the best way to go about it. The other procedure issues that we have vis-a-vis fresh appointees should be best avoided.
Right, thank you, sir. Mr. Farasat, if I could come to you, do you believe that there should be reforms in the appointment process, especially like Justice Shakdar mentioned, that we have a timeline already set, a timeline of 3 months as stipulated in the Lok Prahari judgment? So, you think reforms are required?
No, I mean, I agree with Justice Chakdra's view that this is an emergent kind of appointment. The whole purpose of the appointment is to actually get things moving fast, get an appointment who can, and then they can deal with they can deal with effectively with the caseload. So it should be a very very summary process even for appointment, and the more detailed process which is sought for a regular appointment should not be followed. So I fully agree with him. Plus, if they're retired judges, I think I mean, there are two provisions. One is, of course, in the constitution, there's one for retired judges, which is and the other one is that in addition, you don't need to be a retired judge, you just need to be qualified to be a high court judge. I think the provision which is going to be likely to be used is the one which is for retired judges. In the case of Supreme Court, it envisages also a situation where somebody is a judge of a high court and he's brought in as a Supreme Court ad hoc judge. So retired judges are already effectively vetted by the system. They have served in the system, right? I mean, they have been there, vetted not just by the government and by by the courts, but also by the bar at large. So people do know. So I think generally there should not be much controversy around that, and a summary process should be quite credible in trying to get them on the this thing on the back as ad hoc judges.
Right, thank you. Another criticism of this entire ad hoc appointments is that experts have flagged that it may sideline senior judges who have served for decades, and this in turn can affect judicial morale. And it could also slow down the career progression of judges in the subordinate judiciary. Mr. Farasa, do you agree with this criticism?
No, I don't at all agree. I think for both the reasons you pointed out, I don't really think they arise, because insofar as senior judges are concerned, ad hoc judges are not in competition with senior judges. They are on a separate career track, right? The ad hoc judges are for it, as the word itself means, it's ad hoc, it's temporary. They're going to be there for maybe a year, 2 years, max to max 2 3 years, while getting some disposal done. So they are not there to then be there for any longer. So I don't think it's going to impact any of that. They are not in the normal process of seniority. They're not going to impact the seniority of high court judges to go as chief justices of other high courts, or to get elevated to the Supreme Court. So that doesn't impact. Insofar as the subordinate judges, I mean the district judiciary's promotion, member of the district jury who are then brought in as high court judges, that it won't even impact that, because that space is also open. This is in addition to the existing mechanism, so I don't think it's going to impact that either. If one third of which is the rule which is followed, one third of the high court judges are from the district judiciary, that will continue. So I don't think that's going to either way impact it. It should be looked at, which is what it is structurally, legally, constitutionally, as a separate emergent mechanism to unload the system from the docket explosion which has happened, and nothing more. And it's really nothing else in addition to that.
Right, Justice Shakdar, what is your opinion on this?
I agree with Shadan that this cannot affect senior judges for a simple reason. The article under which they perhaps wish to appoint retired judges is Article 224, capital A, which specifically says that while they'll have jurisdiction powers and privileges of a sitting judge, or let's call him the regular appointee, he or she are not deemed to be judge of that court. So, for the purposes of judicial work, they will have all the powers that a sitting judge has, which is very logical. But they will not do any administrative work, as Shadan rightly pointed out. They are not in line for elevation either as chief justices or to the Supreme Court. So, how is it going to impact sitting judges? In fact, it's going to take a lot of load off them if these ad hoc judges actually work as expected. So, that's least of the worries that one should carry on this aspect of the matter. Rest is something that once they get appointed, we'll know how the this move actually fructifies. Experience will teach us whether this is something that works well, or an idea that should not be taken further. So that's what would be my view on the aspect. So I tend to disagree with those people that it's going to affect senior judges. And as far as, sorry, the second part is vis-a-vis service judges. There again, I agree with Shadan that this is in addition to what is the determined sanction strength of each high court. So as far as their promotion avenues are concerned, they're not going to get closed. Besides, if you look at the present statistics, your working strength in every court is less than the sanctioned strength. I don't think there is any court except for Sikkim, perhaps, as on 1st February 2025, which has appointed judges as per the sanctioned strength. Sikkim, as you know, is a very small high court. It has a sanctioned strength of three permanent judges, and it has in place three judges. The all India gap is nearly one third slots are empty. So, against a total sanction strength of 1122 judges, you have only a working strength of 755 judges, leaving a gap of nearly 367 vacancies. So, whichever way you look at it, it's not going to impact service charges.
Do you believe that this appointment of ad hoc judges could have a strain on the existing judicial infrastructure? This is also something that the union government has pointed out in the budget session, that one of the reasons for pendency is the lack of judicial infrastructure. Do you think more judges on the bench could add strain to it?
No, see, when you have a judge appointed, you have necessarily a complement of people around him uh, who assist him in discharging his judicial duties, which would include his private secretary, his stenographers, court master, other assistants in court. Those are aspects that will have to be dealt with, because you can't have a judge working on the judicial side without these, I call them key personnel, being around him. Now, some of the staff actually are given to a sitting judge to also help him concentrate on his judicial work, because there are a lot of these other aspects which a judge needs to take care of, which are his relating to his personal work. And when you have staff, they kind of help you with all that. Something as simple as taking care of your banking transactions, etc. So yes, they will have to provide him, but perhaps they could rejig what kind of staff they are going to give to a ad hoc judge. They could add more law researchers, because he'd be only concentrating on judicial work. Rest, I guess, he would perhaps not seek or may not want. So as to how many you require for a ad hoc judge as against a regular judge is something that can be worked out. I mean, I don't see that this is something that should really be an impediment. And if the government of India is really keen on reducing the arrears, they should be able to find the money. In fact, this is something that the earlier bench touched upon and said this is something that should not come in the way. There is money available. You can always cut costs at other in other areas, and pour a little money here for a greater cause. So it's doable. In short.
Right. Thank you, sir. Mr. Farasat, what is your opinion on this?
No, I agree that it's doable. I think it's a question of basic intent from the executive to cooperate, like Justice Shakhtar said. So if they want to do it, I think it's not the kind of infrastructure or additional personnel needed, which is, if there is intent, it can be done without a huge problem. So it is something which has to be catered to. You can't obviously just appoint judges without staff or without infrastructure. I think there is enough infrastructure in terms of courtrooms, etc., which should be there in most of the high courts, or it can be adjustments can be made. There are spaces in courts which are not used or used for something else, which can be converted into courtrooms. It's not in the Supreme Court. I have seen in the last 18, 19 years so many spaces where registrar offices are now courtrooms and vice versa. So space can always be created especially if you're going to have four or five new courtrooms needed. So that can be done. Personnel, yes, you will need to maybe reallocate some existing personnel, maybe appoint some new ones on an ad hoc basis, again on a contractual basis, possibly. I don't know, but if that's possible at all. But it's something which is certainly doable if one puts one's mind to it.
Right, thank you. Justice Shakdar, coming to you, based on your experience, do you think the existing system offers enough incentives for meritorious judges to return to the bench? Or do you believe that they would rather opt for arbitration or independent practice?
You've got me on this one. Well, I think it's a matter of choice, but when I was a sitting judge, I would actually encourage a lot of youngsters to opt for judgeship, which I think is an option that increasingly, for the very same reason that you put to me, lawyers are today reluctant to accept. In fact, I am a votary for what I call as a short service commission appointment, which is in the services, where I would tell lawyers at the bar that if you don't want to come in for a long haul, I'm moving away from ad hoc judges appointment, which is that you come in at a young age, as per the practice and custom in place. You are normally offered an appointment when you reach 45. In a few exceptional cases, they have sort of lowered the bar, but 45 is the age at which you are offered judgeship. So I would often tell them that, listen, if you don't want to come in for a long haul, that means you come at 45 and go away at 62, which is a long span. Come in later where you're financially stable, your family is settled, your children are settled, and then come in, say, at 55 or maybe 56, whatever age, for a short period, 7 years or 8 years, do your bit and get out. The only impediment with this thought, as I could perceive, was that you would not be able to practice in the same court. So people say that as long as that impediment is there, it's a disincentive, because a lot of lawyers have practiced in the High Court and then they would have to move to other High Courts or the Supreme Court. Delhi perhaps doesn't have that problem. At least I don't see that as a problem, because you have the Supreme Court, and of course you can go to the other High Courts. That's apart from this ad hoc measure, no one seems to have concentrated on this. That you must have two streams filling in vacancies. The collegium or the government could look at it, because I'm sure you'll find some fine lawyers who would say that after 55 I would put my shoulder to the cause of dispensing justice. As far as ad hoc judges are concerned, you're right. Finding judges who would give consent to get back into the system would be difficult, for a variety of reasons. One of them would be that if you've been a judge in that court and you retired at a particular level, you're virtually right at the bottom of the ladder, correct? That could be a disincentive. Secondly, what perks and privileges they are going to give you, unless they are really attractive, I I don't know whether a retired judge would easily be persuaded to come back into the system. As a matter of fact, Supreme Court, I'm told, is finding it difficult to even find suitable candidates for tribunals which have been set up. So, as I said a while ago, finding a suitable candidate who has the technical skills, who has impeccable integrity, willingness, and passion to do the job would be difficult, because of the lack of fleshing out of the aspects that I just mentioned. how do you incentivize they coming back into the system? So while these directions and orders have been issued, implementation and seeing that they see light of the day is a tough ask.
Right, thank you, sir. Mr. Farasat, if I could pose the same question to you. As a senior advocate, do you see senior lawyers especially forthcoming to taking up judgeship on an interim basis?
Yeah, I think what I'll just repeat what Justice Shakdher said. I think in a lawyer's career, the journey, the priorities are different at different points in time. So, like you put it, I think there will be a lot of lawyers in their mid 50s with things more settled in terms of personal spaces and family and financially, who would be willing to then take on that as an ad hoc basis. Because you see, the choice is if you're at the uh, peak of your career in terms of trying to sort of get there, and then suddenly an interruption of 5 years. So at an earlier stage, a lot of people will be reluctant because nobody will want an interruption and then get back into the system after 5 years. But yes, at a more later stage where you've had a longer tenure and you're not necessarily that keen on keeping that same pace of work, even once you're back, you may be more open to something like a shorter service term, and just to be part of the system on the other side. So I think that's there. In fact, I have a question for Justice Shakdar also. I mean, if my question to him is that he was a senior counsel before he became a judge. Then he served a long distinguished career as a judge, and now he's again a senior counsel practicing in the Supreme Court. What's the difference in terms of the system he has seen now? Now that he's back in it, what's changed for him? What are the big differences he sees, both in terms of pendency and also in terms of are there any other obvious changes?
See, I think uh, coming back as a lawyer after having done a fairly long stint, I did more than 16 and a half years. Two things are very clear to me that I have become more appreciative of the job that judges do. I understand the pressure that judges have, and that most of them are trying to do their best in trying to in attempting to dispose of cases, etc. It's not happening because the caseload is very heavy. Whichever high court you go to, whichever even the district courts, it's very heavy. Supreme Court, I see it day in and day out that judges are just sort of swamped by cases. So much so that in good old days, what has changed is good old days we used to have at least 3 days in a week, which were regular days. That means you got to argue matters at a particular pace, which means you got about 2 hours each side minimum would be allocated to each side to argue a matter. That is not happening, and the reason, as is evident to me, is the caseload burden. The judges are trying to, at least, in the very least, finish those that can be disposed of. It's the low hanging fruit approach that the court has adopted. Now, so in that sense, the court has changed. Personally, I think it's like a third inning for me. I mean, when you get to court as a lawyer, something that you've not done for 16 and a half years means you need to sort of dust your gown, sort of brush your skills, and acquire skills of, let's say, I don't. The nearest I can think, you are like a gladiator. So you're briefed by one side, and you do your best. Of course, keeping in mind the rule of law and the ethics of the court. As a judge, there is always right and wrong. As a lawyer, you argue the brief that you're given without compromising on integrity. So, Shadan, my answer to this is something that I said in court the other day also. It is It was told to me by someone who happened to speak to a prominent and an eminent chief justice who was a senior counsel in that court, as to what's the change. He says, when I was briefed for a litigant, I was briefed to breathe fire. And when you become a judge, then perhaps you are the calming effect on the bench. You have to decide. So, yeah, that's the change.
Very well put, sir. Thanks for the insight. Mr. Farasat, would you like to ask him anything else?
No, I just, I mean, that's quite true. Actually, I now that Justice Shakdar has flagged it, I also see it. In fact, even when I started my career as a lawyer, which is 18, 19 years back, you did have three clear days: Tuesdays, Wednesdays, Thursdays, for longish, what we call leave granted matter hearings. And now it's been reduced as of now to one day. And I think the worry is that the court won't have any time. I mean, already most high courts don't have time for regular matters, and I think that's the direction the Supreme Court is sort of going into, and it's the workload to blame. What do the judges do as well? So I fully agree with him, and of course, it's great to be working with him alongside him. We have all appeared before him, and now to work alongside him in the Supreme Court is something which is very satisfying.
Right. If we could now proceed to the last question for the evening, which is, do you believe that ad hoc appointments, this process, does it raise any concerns related to judicial independence? Mr. Farasat, if we could please start with you.
No, not at all. I mean, see, as I see, judicial independence is a state of mind, right? I mean, you have to be very clear that when you're sitting as a judge, you're doing what the matter requires you to based on the law and facts. And therefore, just the fact that you were at the bar until yesterday, and then you are here, and then you'll be again back at the bar in some time, maybe, is not necessarily any dis it takes away from judicial independence. The classical view was that, of course, judges had to be completely, not completely, but substantially segregated from the society and even at the bar. But I think that view has broadly broken down, and not necessarily for the bad. I don't think social interaction in any way takes away from judicial independence. So just the fact that judges will come in for a shorter bit and then go back to the same space where they belong is in no way, as I said, it's a state of mind. You can be meeting a person one day socially, but in the next day in the court, it's going to be the merits of the matter which is going to determine the outcome. And we see that day in, day out. And as lawyers, and I'm sure all the judges are very well aware of it. So it's not something that I don't at all think that it's going to impact judicial independence.
Right. Justice Shakdar, what is your opinion on this? Any concluding thoughts?
No, as a matter of fact, this may help the system. I'll tell you why. First and foremost, what we started by saying is, if you choose the right candidates, then this shouldn't be a problem. This shouldn't even cross your mind. In the sense, people with integrity who have done their job well while they were sitting judges wouldn't have a problem. Secondly, see, when you get appointed as a judge, you get into a service environment as against when you were a lawyer, because at the bar, you just arguing your cases. You're not employed by anyone, and if you're a senior advocate, you're engaged by a advocate on record, and that's it. It's a profession. You're in free space. You say and do whatever. But when you get appointed as a judge, and whether you come laterally or otherwise, you get in. As I said, you get into a service environment, and then there is this legitimate. I call it. I'm underscoring it. Legitimate expectation that you will rise through the ranks. If you are a service judge from the district court to the high court, and if you're a judge in the high court as a chief justice or to the last court, there's nothing wrong with it. But sometimes it has its own, let's say, issues which are not necessary for present day discussion, and not necessarily the most hardworking, the best judge gets his dues. So there is that element of dissatisfaction. The system loses, the gentleman or the person concerned perhaps may also have that kind of feeling. But it's how you are as a person. If you are a person who thinks that, I do what I do, where I am, it doesn't matter where I go, then it shouldn't bother you. But as I said, it's a legitimate expectation. Now, when you get appointed as an ad hoc judge, this bit should not bother you. You are there, you do your job and get out. Similarly, as I said, the other model, if you follow for lawyers who come for a short period, say for 7 years, independence will actually increase because they're not looking for any higher office. They do their job and they come out of the system. So, it shouldn't be a problem, provided you have the right candidates.
This brings us to the end of the discussion. Thank you so much, sir. Thank you, Mr. Farasat. It was lovely conversing with the two of you.